morning, everyone. My name is Rachel Supay, General Counsel for the State Board of Education. We're going to give everyone a few more minutes to trickle in person and online, and then we'll go ahead and get started. Good morning, everyone. Thank you for attending today's rulemaking hearing regarding state board rules governing school safety, universal student screeners and the state adopted benchmark assessment, residential mental health facilities, and charter schools. Today is October 8th, 2024. It is now 10:33 a.m., and I will call this rulemaking hearing to order. My name is Rachel Supay. As the General Counsel for the State Board of Education and their designated representative, I will be presiding over today's hearing. Information on how to join this rulemaking hearing can be found both online and in the agenda for today's meeting. It contains instructions for how to attend in person and online. This information was also filed with the Secretary of State's office and posted to the State Board's website. Since this hearing is being held both electronically and in person, I want to remind all attendees who are joining online to please keep yourself muted unless asked to unmute. If you are attending in person, I will also ask that you remain quiet so that online attendees can hear and be heard. Any attempts to disrupt the hearing will result in removal from the hearing either electronically or in person. A redline version of the rules under consideration at this hearing are available both here in person and on the State Board's website under the link for today's meeting. This hearing is also being recorded and will be provided to state board members for their review. Getting into the rules that are subject to today's hearing, State Board of Education will gather feedback from the public regarding the following rules. School Safety Rule 0520-01-02.30, Universal Student Screeners and State Adopted Benchmark Assessment Rule 0520-01-03-0.15, Residential Mental Health Facilities Rules 0520-01-02.02 through 0.05. And lastly, Charter Schools Rule 0520-14-01-0.01 through 0.03, and 0.03 through 0.05. I will now begin with a summary of each of the proposed rule revisions. The first item is School Safety Rule 0520-01-02.30. This item proposes repealing the State Board School Safety Rule 0520-01-02.30, as the requirements for those school safety laws are already contained in statute, and there's no need to duplicate them in rule. The SAVE Act, passed by the Tennessee General Assembly, established specific and consistent requirements for districts relating to providing a safe school environment, including the formation of district and school safety teams and the requirement for the development of comprehensive safety plans. Furthermore, this rule contains requirements for districts to conduct at least 2 earthquake drills a year if the district is within 100 miles of the New Madrid fault line. Previously, state law required districts within the New Madrid fault line zone to conduct earthquake drills and required the state board to promulgate rules to effectuate this requirement. The requirement was removed from the law in 2018, and therefore state board rules on earthquake drills for districts within the New Madrid fault line are no longer relevant or necessary. The next item is Universal Student Screeners and State Adopted Benchmark Assessment Rule 0520-01-03-0.15. This rule section outlines requirements for local education agencies and public charter schools to annually administer approved universal reading screeners for students in grades kindergarten through 3rd grade in accordance with the Tennessee Literacy Success Act. The rule also effectuates the requirements of the Tennessee Learning Loss Remediation and Student Acceleration Act regarding the use of benchmark assessments to identify priority students for summer programming and for pre- and post-test requirements. However, Chapter 639 of the Public Acts of 2024 amended the Tennessee Learning Loss Remediation and Student Acceleration Act to remove the requirement that local education agencies and public charter schools administer a pre-test in summer learning camps, after-school mini camps, and learning loss bridge camps. As such, this item updates the rule to remove references to pre-test to align with Public Chapter 639. The next item is Residential Mental Health Facilities Rule 0520-01-20-.02 through 0.05. These rule sections outline requirements for the admission of Tennessee public school students to out-of-state residential mental health facilities in accordance with TCA 49-3-370. The State Board previously approved an emergency version of these rules on July 15th, 2024, to align to the changes that were made by Public Chapter 884 of the 113th General Assembly. This rule also proposes making those revisions permanent, including removing the requirement that the residential mental health facility serve at least 15 Tennessee students per school year. Additionally, this item makes permanent the removal of the condition that the student have an active individualized education program, or IEP, at the time of the student's placement at the residential mental health facility. Lastly, the condition that the student be enrolled in and having attended a Tennessee public school for the full school year immediately preceding the student's placement at the facility is removed, and instead requires the student to be enrolled in and attending a Tennessee public school at the time of the student's admission to the facility. The last item is Charter Schools Rule 0520-14-01-.01 and 0.03 through 0.05. These rule sections outline various charter school and charter authorization requirements, including the approval of a charter school, allocation of state and federal funds, and student enrollment. This item proposes multiple revisions made to align with both Public Chapters 923 and 1066 of the Public Acts of 2024. First, to align with Public Chapter 1066, outdated funding language regarding the Basic Education Program, or BEP, is being removed. Next, the rule specifies funding requirements for the first year for a student who transfers to an opportunity charter school located in an LEA other than the one in which the student resides. A definition of an at-risk student and the enrollment preferences for an opportunity charter school are added to the rule as required by law. The rule also specifies the types of documentation that can be collected by the charter school to verify that a student meets the at-risk enrollment criteria. The revisions also include a requirement that the authorizer conduct an evaluation of an opportunity charter school's at-risk student enrollment, and next steps should an opportunity charter school fail to meet the 75% at-risk student enrollment requirement for 3 consecutive years, as outlined in law. Additionally, Rule Sections 0.05 is revised to align with Public Chapter 923. These revisions include a timeline for an LEA to report and publicly post its vacant and underutilized properties, as well as definitions of what constitutes a vacant or underutilized property, which the LEA is also required to include in its annual report. With those brief explanations, I will now move into the public comments portion of today's hearing. Please note that the rulemaking hearings are an opportunity for the State Board to collect feedback, and the proposed rule language is not meant to be a question and answer session. During public comment period of this hearing, please state your name and organizational affiliation, if any, before making your comment. Each person who wishes to speak will be allotted 3 minutes. We have one speaker here in person, so we will start with our in-person speakers. When they are complete, I will be calling on our online speakers next. Whenever you're ready, you can state your name and your organizational affiliation, and then you can begin your 3 minutes of comments.
Thank you. My name is Zoe Jamal, and I'm the policy coordinator with Disability Rights Tennessee. DRT is the state's protection and advocacy agency for persons with disabilities. In addition to advocating for the rights of people with disabilities, we conduct routine monitoring of and investigate claims of abuse and neglect in residential facilities serving persons with disabilities. Our organization is familiar with the various types of residential settings for children in our state, and we are painfully aware of how those settings can become places of horror when they are devoid of services, inadequately funded, and short-staffed. We are also aware of a trend toward unnecessarily segregating and institutionalizing youth with disabilities. We believe children, including those who are at risk, belong in homes with families and in schools with their peers, not isolated in facilities. Accordingly, DRT has an interest in ensuring that residential settings are subject to appropriate departmental regulations and licensing, robust policies, and meaningful oversight. We note that establishing a new type of congregate setting for children who have experienced trauma of removal from their families and communities, and then cutting them off from loved ones and the public in general, is dangerous for young people, especially those with disabilities. Residential facilities for troubled youth are notorious for abuse, and youth with disabilities are at higher risk of abuse in those settings. Up to 85% of abuse cases go unreported in congregate care settings. One of the things that prevents ongoing abuse is contact with family. Accordingly, our comments today focus on enrollment in residential opportunity charter schools located at Rule 0520-14-01-.04 in the Notice of Rulemaking. Opportunity charters are predicated on parental choice when it comes to enrollment. In that vein, we hope to see additional language from SBE that prevents at-risk children from being placed in these schools by the state. This might look like express language that a parent legal guardian must be the one to submit an application for enrollment. This is important when it comes to preserving parental rights because residential opportunity charter schools seem to offer an avenue through which an education entity could compel out-of-home placement for some students. Juvenile courts also have the authority to modify educational placements and can order youth adjudicated delinquent, even for minor offenses, to institutions and facilities operated by local public authorities. By specifying that only a student's parental figures, be they biological, foster, or kinship relative caregivers, can submit an application for enrollment, SBE can ensure that the choice to enroll a student is truly the parents, and that these settings do not interfere with state's responsibilities when it comes to serving at-risk youth. With regard to this same subsection, creating the definition of residential opportunity charter school, DRT has grave concerns about the lack of specifications and details proposed by the rule language. Currently, there is nothing in the Notice of Rulemaking that addresses how these facilities will be licensed, funded, or staffed, and there's nothing in the rule that identifies how the special populations contemplated for residents will be served. It's important to note that the type of congregate setting proposed here differs substantially from any other state-run residential school. Both Tennessee School for the Deaf and School for the Blind are residential, yes, but students maintain connection to their families and communities by returning home on the weekends and during school breaks. No such maintenance of family contact or even parent participation on the board is contemplated for residential opportunity charter schools. Tennessee School for the Deaf and School for the Blind are also staffed with one professional for every 3 students, and they specialize in serving one particular population. It doesn't appear residential opportunity charters will be required to adopt a similar model under the rule language. Furthermore, the per pupil spending at those schools far exceeds what would be allocated under TISA for residential charters. We have concerns about statements from the sponsors of the bill that established these schools that they could partner with nonprofits to provide housing. While there is a time and a place for nonprofits to step up and with adequate guidance and support provide services for youth, we need only look at the problems arising in the Department of Children's Services transitional houses to see how unlicensed residential settings can do more harm than good to children in the absence of a robust regulatory scheme. Just last fall, media reported about a 12-year-old with autism and intellectual disability being restrained and hogtied by private security in a nonprofit transitional house. The only guidance in the rules specific to a residential opportunity charter school states that the residential model must include, quote, living arrangements that are age appropriate, close quote. Does the SBE or DOE plan on promulgating additional rules about what it means for living arrangements to be age appropriate? One of the categories for at-risk students is students who have dropped out of high school, meaning they could potentially be older students, and there's no statewide requirement that youth over 18 must attend adult school. Students with disabilities are eligible to receive special education services until the age of 21. So would living arrangements be age appropriate if 21-year-olds and 12-year-olds are living together? Furthermore, is age the only consideration for determining whether the living arrangements in a residential facility for students who have been identified as at risk are appropriate? We think not, and urge SBE to provide additional language in the rules related to what makes for appropriate living arrangements in a residential opportunity charter school. Considerations that should be taken into account certainly include age, but that cannot be the only factor, especially when we are talking about various cohorts with specialized needs. We believe additional considerations must be included in the rulemaking language to ensure the safety, well-being, and academic success of youth who may reside in opportunity charter schools. And we will submit written comments with more details about what types of considerations we would like to see. Thank you for the opportunity to provide comment, and I'm happy to answer any questions.
Thank you so much. Since we don't have any additional commenters here in person, I'm now going to switch to online attendees. So if there's any online attendees who wish to make a public comment, please feel free to either unmute yourself right now to announce your name, or you can type your name into the chat, and then I will call on each of the online attendees one at a time to speak. Again, if there's any online attendees who wish to make a comment, please feel free to unmute yourself at this time and share your name, or feel free to type it into the chat. Okay, seeing no speakers online, on to the next portion of our hearing, just to make some final announcements about next steps. You may submit additional written comments regarding these rules for consideration using the contact information noted on the agenda on our website and up on the screen. If joining by phone, the email address to submit comments is Danielle, DANIELLE, .Nellis, NELLIS, @tn.gov. These comments must be received by Friday, October 11th at 9 a.m. Central Time in order to ensure consideration. Email is preferable as the regular mail has been running very slow and may not arrive to our office in time. It's anticipated that the board will vote on final reading of these rules at its quarterly meeting on November 22nd, 2024. Specific details about that meeting agenda and how to attend or watch the meeting online will be posted on the State Board's website under the meetings page. If the board approves these rules on final reading, they will be sent to the Attorney General's office for approval. They will be published on the Secretary of State's website for 90 days, and they will go before the Joint Government Operations Committee with the Tennessee House and Senate. The State Board of Education appreciates everyone who took time out of their day to attend today's hearing. With no further business on the agenda, this hearing is now adjourned. Thank you.